And good afternoon, everyone. Welcome to our MPF webinar this month. And we're delighted to have Carson Pearson and Whitney Cunningham back to talk to us about alternative business structures, multidisciplinary practices, and the regulatory reforms out in Arizona and Utah, and kind of bring us up to speed what's going on. So Carson, Whitney, thank you so much for coming back to us. And Uri, as always, thank you for co-moderating our program.
My pleasure. Good to be here.
So Whitney, where sit you today? Our audience doesn't yet know.
I am at home in Flagstaff. We got about a foot of snow yesterday, and since I can't get down my driveway, I'm working from home. It's not so bad.
Good on you. And you've warned us that if we hear, barking animals, not to be alarmed. So thank you for.
From here, they're my dogs. When you hear that at the office, it's the associates, but one way or the other.
I was talking about your dogs, Whitney. Not. And Carson, how are you? Where sit you this afternoon?
Fantastic. I'm just in my office in beautiful Salt Lake City. We're just prepping for the NBA All-Star game, so things are getting kind of busy here.
Oh, yeah.
Salt Lake City is beautiful. If you haven't been, folks, go check it out. And Uri, you're stateside for a change, huh?
I am sitting here in lovely northern New Jersey, suburb of New York City, and it's a nice sunny day today.
And they don't call it the Garden State for nothing.
There you go.
And I'm here in Syracuse, New York, and it is 72 degrees outside. And people are like freaked out, wanting to go walk around or do something. And it's unbelievable, the weather here. So again, gentlemen, welcome. Thank you so much for being with us. And we are approaching the top of the hour and like to keep things running on time. So let's jump right in. Welcome, ladies and gentlemen, to the MPF webinar series. This is, I believe, Uri, our 34th webinar since COVID hit. And I know it's unbelievable. And as we mentioned, we're going to be talking to Whitney Cunningham. We'll introduce him shortly, and Carson Palmer. But for now, Uri Goodfreund, my partner in crime and co-host. Welcome, Uri. Good to see you, as always.
Good to see you too.
And before we jump into our topic, we'll be quick because we listen to our audiences. You want us to jump right in, but we do have to, bring a couple of shameless plugs. Our webinar series, we're doing these the third Wednesday of the month. And we've got a nice schedule coming up, some really interesting topics, and we encourage you to check us out. These are free, and they're all archived on the website, the handout material, as well as the recordings. Our big signature events coming up in just a couple of months, May 3, 4 in Atlanta. We're going to have our MPF Leadership Conference, and 100+ managing partners from around the United States, Canada will join us for what should be a great program. Early registration's open if you want to check us out. It will sell out, so register early if you want to assure yourselves of a seat. We'll do a fall symposium this year in Chicago as well. Details where I think we're going to go with an all-women's conference, empowering women in leadership. We got our newsletter, website, all those good things going on, trying to help managing partners be more effective in a very challenging role. Today's program, ownership reform, law firm ownership reform, and what's going on in those regulatory sandboxes in Utah and Arizona. 80 managing partners, firm leaders registered for today's program. And as always, we bring plenty of fresh survey data, and you answered some questions as you signed up, and we'll do the reveals. And then throughout our hour today, we will sprinkle in some audience polling questions. As mentioned, this is all recorded. We want your feedback. Always listen very intently to what people have to say. So when you hang up from today's program, it'll direct you to a landing page where you can tell us what you like, what you didn't like, topics for future programs. Our next program will be on the third Wednesday of March, the 15th of March, and stay tuned for details. We've got two of my favorite managing partners, and I don't say that to every managing partner. Whitney Cunningham, Carson Pearson. Whitney is the managing partner at Aspey. Let me get your firm name right here. Aspey, Watkins, and Diesel. Founded in the mid-70s at about 20 lawyers, Flagstaff, Arizona. Whitney is the past president of the State Bar of Arizona. He was in-house for a number of years and got his law degree from Georgetown University. Whitney, welcome.
Thanks, John. Glad to be here.
And we are glad to have you. Did I miss anything in your introduction that people need to know?
You made me sound better than I am in real life.
Hardly. We're just scratching the surface here. And joining us as well as Carson Pearson. And Carson, a very entrepreneurial managing partner in Utah, South Jordan, which is a Salt Lake City suburb, founder, managing partner at Pearson Butler. At 32 lawyers, a dozen or so practice areas, doing some very interesting things in and around alternative business structures. And Carson's a BYU law graduate. So Carson, glad you're here. Welcome.
Thank you for having me.
And thank you for being here. Our first test question, we always like to do the test question, the polling questions. You guys know that. And let me pull it up. Audience polling. There's questions, handouts. Where's the polling tab? It was out there a few minutes ago. There's handouts, audience view, chat view. I'm working remotely here, folks. So those of you who know me know technology challenges me, and I can't find my tab for polling questions here. So I'll be fumbling around for them as we go and try to come back. But the first question we wanted to ask and present results was about firm size. And most of our participants are mid-law, soundly mid-law. And again, I'm trying to find my polling questions here. And I can't get to them, guys. I apologize. So we may lose that feature today's program. We wanted to ask the audience's opinions of multidisciplinary practices, alternative business structures. Are you strongly in favor of the concept? Somewhat in favor of the concept, neutral, highly, somewhat unfavorable to the concept, or highly unfavorable to the concept. And again, I'm able to display the polling questions for that. I'm sorry. We asked when you register. Here's some benchmarking data. How important is the access to capital for your law firm? Here's what you said. 60% say it's important. 24% said it's very important. And how important is technology to you and your practice? Overwhelmingly, 7 out of 8 of you said it's very important. And only 1 of you said it's not important. So technology is important. And I know, Carson, you wanted to make a point here about this. Capital, technology.
Well, one of the things that I noted is everybody, I think, believes that technology is important to their practice. As you see, 88% very important. It takes capital to have the most current technology and to get it implemented across the firm, whether it's your contact management systems or your research technology or marketing technology or KPIs. That all takes capital, both for the software that comes in, the hardware, and then of course the people to manage all of that. So I think the access to capital becomes important, not just from case management and running your firm, but if you're going to have the cutting edge technology.
So do you see a little bit of a disconnect here, Carson, and what people are saying? That technology is really, really important, but capital not so much? Are those kind of inconsistent?
Yeah, I guess the follow-up question is, if technology is very important, do you have all the technology you want? Are you satisfied with your technology now? And my guess is most people have a lot of areas that they would like to better serve their clients and be more efficient in their firms with technology, and that they're holding back on that for capital. So I do believe there might be a little bit of a disconnect on that.
John?
I agree with you. Yes, Uri?
I think the question also, just to add to this, and I think Carson's getting to it, which is to the partnership, how much current income are you willing to forego to improve our technology? And I think that's often the conversation. And Carson, sometimes those are big numbers, and I'm not sure you get all that partner buy-in.
Well, and what I see, Uri, is in many firms, the senior lawyers are controlling the votes and decisions, and they're not so inclined to want to invest big bucks into the future. They kind of want to cash out a little bit, and there may be a reluctance on some of the seniors to support big investments in technology. By the way, my bumbling and fumbling paid off. I found the polling questions, so let me jump back here. I know, right? Right? And, I always comment that I'm from Georgia. We know how to run elections. You can see it here happening live, right? So here we are, everybody. Our first polling questions as to firm size. If y'all would go ahead and let us know your firm size in terms of lawyer head count. And that'll give Whitney and Carson a perspective as to the firm sizes represented today. We've got about 70% of you in, having voted. So I'm going to go ahead and close it, share our results. So that gives you a sense of the firm sizes here, gentlemen. And as Uri likes to remind me, hide the poll and then move on to the next question. And that gets back to your personal opinion about alternative business structures, multidisciplinary practices. Are you strongly in favor, somewhat in favor, kind of neutral, somewhat opposed, or strongly opposed to this concept? And I'm going to ask Whitney to predict what he thinks the mood of our audience is on this question.
I think a lot of folks haven't thought this through all the way yet, haven't had to. So my guess is we're going to be in the neutral or somewhat opposed category.
And Carson, care to venture a prediction?
I would agree with that. I think opportunities like this to discuss the issues and what's really going on in the marketplace in our industry is very beneficial. And I just don't think a lot of that has taken place.
So you would agree with Whitney that you think most people are going to be somewhat disinclined to want to be too favorable on
I would say
these?
neutral to somewhat opposed. I think a lot of the neutral is I don't know enough about it yet.
Look at that.
I was wrong.
Look at that. I'm surprised to see this too. That I am too. Compared to previous times, we've asked this question. Now, of course, the audience here self-selects.
Self-select, John. Yeah, these are the people that want to know about it.
Well, that's correct. But we've asked this same question. Last time we had Whitney and Carson 2 years ago, it was a whole different attitude. And we saw a lot more opposition to the concept than what we're seeing here. So I agree there's a little bit of self-selection. It's hardly scientific, but there you go in terms of what folks are thinking about these structures, today's group. So here we talked about capital needs. And the next question we asked at point of registration was, do you think technology companies are competitive to you and your law firm? Here's what you said. Carson, should we be more concerned?
I was very surprised by this. Technology companies are rapidly eating away at the market share. They're not licensed or under the same compliance structures. If you're in contracts, end-of-life planning, family law, bankruptcy, immigration, any of those fields, your market share is going down by pure technology companies that are coming in. If you're dependent on clientele through any marketing efforts outside of your personal networking, you're also seeing technology companies come in and dominate the structure of how the client is finding you. And I see it as a major threat to us as attorneys and whether we're going to be involved in what that future looks like or not, but we're losing market share rapidly. Rapidly.
And we're talking about LegalZoom and Rocket Lawyer and outfits like that.
Into jurisdictions like Arizona and Utah, I know Whitney does the same, and they're very proactive and they're highly capitalized, quite frankly. much more so than we are as attorneys.
Whitney, would you agree with what Carson just said? The technology companies are grabbing market share rapidly from traditional law firms?
That's true. We're seeing it, and it's not just a Utah or an Arizona phenomenon.
No, it's not.
It's one of the things that gave rise to our Supreme Court's creation of the task force that led to our change of rules, because these companies like LegalZoom were so heavily funded and prevalent in the market that they dwarf in size, political and legal power our own state bar. We had to come to grips with a way to protect the public in the delivery of legal service while trying to figure out a way to regulate but allow these services. And now, for example, in Arizona, our court has approved about 40 alternate business structure companies, and they are across a continuum of purposes and goals, but some of those purposes are to deliver legal services through better use of technology. So it's here, and it's only going to accelerate.
Carson, in Utah, similar stuff
Very
going on?
similar. I do want to echo one of the things that Whitney said. This is not a Utah and Arizona issue. It's really nothing to do with the sandbox or innovation. These are national tech companies that are already providing legal services as we would define them, and that they're just coming in and seeing how they can expand out what they're already doing.
Wow.
And that's serving the public. So they're not under the same rules that we are, and yet we're losing business to them, and we're not on an even playing field.
So this slide we're looking at now, it's like, folks, wake up. These technology companies are a competitive threat, and you can either stand by and watch it go down or do something to get involved. And we talked a little bit our rehearsal call Monday evening about what should a mid-sized firm, a leader of a mid-sized firm, maybe be thinking about. What advice might you offer? Whitney, I'll ask you first.
So what we've tried to do is see the opportunity that comes together with the threat. What it means sort of on the ground in a day in and day out sense for us is we have to be tuned in to price pressure on what you would consider more of the commoditized delivery of legal services. So these are things like estate planning, for example, is probably a prime example. And then you have to ask yourself, are we still in a position to deliver these as properly for clients, but in a way that's profitable to the firm? Things like litigation, things like high-level business counseling, divorce law. There are still a lot of areas that I think require personalized legal attention, and so there's a push to be more prevalent in those areas and look, I think, more warily at some traditional areas of the practice of law that are going to be overcome more quickly by technology. So that's one of the things that we're doing. The other thing that we're doing more medium and long term is to marry up with some of that capital to allow us to be better, to be a better technology company. The software that we use, the client web portals, and the things that clients now come to expect because they know that these offerings are out there. And it was at some point, I'll talk more today, but it was this disassociation of traditional law firms from capital sources that helped to drive at least my own personal view of the rule changes in Arizona. So I think that they're positive. But now we as lawyers who counsel clients, I'm a business lawyer, I counsel clients every day on capital, but we have to take some of our own advice and apply it to our own delivery of legal services.
Here's another question we asked at point of registration. Carson, you provided this one. You want to talk about this for a bit before we move on to our next live polling question?
Yeah, I mean, this is one of the things that we're exploring in our firm, and that's the ability to provide services, especially more predictable, inside the box, form-based services through a paraprofessional that can be trained, that we can oversee, that can interact with the client at a much lower and efficient price point. They've got the backing so that the attorneys are available, but aren't necessarily involved in again, some of the more routine things that we do as practitioners. And I think this will really help on the access to justice side that people are looking at. It will allow a new market segment to access counsel and advice, good counsel and advice, without relying on Google.
This is another question. We wanted a little nuanced litigation, and perhaps this is particularly something litigation firms should be looking at. And again, just to give us a sense of who's in the room, what types of firms are here. And Carson, as people are responding to the question, and you can change your vote, by the way, kind of where are you getting it with this litigation? And you had mentioned you were at the AHA meeting recently, and the plaintiff's bar is all abuzz.
I'm trying to be informed and look at all of the possibilities that are coming in. That this is new across our industry, both in Utah and Arizona, but also it's being looked at and evaluated across the country. The thing that I've really personally found is that it really does depend on your areas of practice. Many of the issues that you're facing are going to be very different in a litigation firm versus a services-oriented firm. So your practice area, I think, does dictate and affect the landscape that you're dealing with this on. And that's the first thing I would do if I'm a managing partner. What are the threats and the advantages based on the areas of practice that my firm has? Because they're not always the same in a global discussion.
Carson and Whitney, if you were ranking which areas of practice you think are on the cutting edge here, either from the perspective that's already being eaten by tech companies or that's the greatest threat, which ones do you see?
I'm interested in what we see coming along in artificial intelligence. I think it'll impact even litigation, for example, because you already have it in a sense. Every time we receive a brief, I plug it into Westlaw, and Westlaw checks all the citations for me. Every time I write a brief, I plug it into Westlaw, and Westlaw makes recommendations of different arguments or cases or legal citations to use. And I think that's just at the beginning. I think it'll be pretty soon that AI is sort of writing our briefs for us, and that's coming. But right now in my firm, we do a lot of family law work, and we use, by the way, a legal paraprofessional. We have a couple of dozen of these in Arizona, and we have one in our firm. And in fact, the partnership voted a week ago to make her a partner in the law firm. So now we're going to become an ABS.
Good on you.
And then also we have a thriving personal injury practice. And one of the places that I think you're seeing technology push really fast is into dispute resolution services. And I know this is already robust in some areas in Canada, but if folks can, right now, in the prior state, a few years ago in Arizona, you would have 80 to 90% of divorce litigants being unrepresented. Having a legal paraprofessional, by the way, helps us to reach more market share because she can deliver those services at a different price than my, senior partner.
Or he, Whitney, or he.
I'm referring to actual people in my firm.
I'm just so sensitive to
but there are and will continue to be now online and technology-driven dispute resolution services. And once those start to make inroads into those practice areas, then that'll really pinch. And so we have to be prepared to pivot and look for other areas.
we're gonna drill down a little bit more and talk. I want to get this last polling question out there, and then we'll carry forth. And Carson, this was another question you suggested we present, and look at those results. What do you think of that?
I would agree with those results, but I believe that they're concerning for us as a profession. The needs that individuals have, they say an ounce of prevention is worth a pound of cure, and I don't believe we're doing a very good job at getting out and helping society at large to get into the prevention mode. I believe one of the reasons for that is we don't operate in our legal industry the same way other businesses do. Our marketing rules and our access to capital simply don't allow for it. So we are way behind on that, and I think that there's harm that is already inherent into that structure as we've moved forward the last 100 years, and technology and the way that consumers access justice or access legal counsel has changed. So how do we get the word out?
Yeah. Whitney, does this shock you, what you're seeing here? Do you agree with these polling results?
I do agree. It doesn't shock me. In fact, to build on what Carson was saying, this was a real driver for me when I served on the task force that changed up our rules in Arizona. We operate on a cash basis. We empty our coffers every year. Saving capital is hard for us because it means, what we call in our firm, we call that the phantom income hit that nobody likes to take.
Yep.
And so we don't marry up with capital like virtually every other industry does. And so what it meant was we're not getting the job done. Legal needs are going unmet. I mentioned the 80 to 90% statistic in Arizona with regard to divorce cases. That information came right from the Maricopa County Clerk of the Court, and is pretty shocking. So we're not meeting the market needs, and as Carson points out, we're terrible marketers for ourselves in terms of making sure that the communities know what we do, when they should call us, and how we can help them. We love to get positive feedback from clients, and I'm sure that a lot of the managers on this call understand this. A lot of the time, that feedback is, "Thank you so much. Your help was great, and it didn't cost nearly as much as I thought it was going to cost." So we're kind of a mystery to folks. But if we as lawyers don't position our firms in a way to be ubiquitous in the communities and have folks know what we do and what it costs and how to access us, then I'm confident that some other technology company will take over that for us in every area they possibly can.
Let me kind of shift gears a little bit, and Uri, chime in if you feel. Just kind of the big picture overview. When the regulatory reforms were set up in Utah, you talked a little bit about the impetus and what it was setting up and the access to justice. Give us kind of that 30,000 foot view of what Arizona's got going on. And then we'll talk a little bit about how law firms are responding, how your firms are responding, and carry forth from there. So, Whitney, give us a big picture, Arizona. What does it look like?
In Arizona, there were what we thought two initially really dramatic changes, but it turned out to be that there were three really dramatic changes. One was the creation of this new position of legal paraprofessional, and they are short of law school, but with if law school takes 3 years, this education probably takes 1. It involves a background check and involves a bar exam. These folks are then able to practice without the supervision of a lawyer, but in described areas, not just free for all like a lawyer would be, but one of the areas is in divorce law. And I'm already hearing from lawyers down in the Phoenix area complaining about the competition that they're receiving from these ill-prepared practitioners. And it's funny because, first of all, there are only 24 of them. And so if you're, I say if your divorce practice is really suffering because of 24 LPs, you might want to look inwardly. We're hearing what I've heard is very positive feedback from the judges that these folks have done a really good job. So that's change number one. Change number two.
They have continuing education, licensing requirements, all that good stuff.
Yeah, they have to pass fitness and character. It's not a small thing, and it's probably why I know we've had a couple hundred applicants, but to my knowledge, only a couple of dozen, maybe 3 dozen, have been licensed so far. We created what we call this alternate business structure, which allows for non-lawyer ownership of law firms. So it was an elimination of our ER 5.4, which is modeled off the ABA 5.4. And so this is you got to submit an application to the court. It's extensive. There's a $6,000 filing fee for just a simple one. But you come out at the other end of that with accountants, bankers, financial planners, you name it, as owners within a law firm, and it's regulated by our Supreme Court.
I was going to ask who approves it. It is the Supreme Court.
It is, and you have to make extensive disclosures about your business plan, about your owners, about how you're going to comply with the ethics rules and all this kind of thing. We're up to about 40 approved ABSs in Arizona. As I mentioned, my firm is applying to become one because we want to have a non-lawyer, an LP, be a partner in our firm. The other thing that we'd like to do is give something in the nature of stock options to our key employees and use it as a retention tool. But in Carson's experience has been different, but you can let your imaginations run wild as to what those can be. The final thing, John, which I didn't appreciate the full significance of at the time, was we changed our rules to allow for payment of referral fees. And so that regulation is now pretty much to the side, and you can pay a referral fee to anyone who brings cases. And one reason that that's important is because ABSs, as it turns out, aren't a great vehicle for some of the things that my clients want to achieve. And we can talk more about that. It has to do with being licensed in multiple states. But because Arizona lawyers are allowed to share fees with non-lawyers, we can contractually do things that even the ABSs don't allow us to do. And so in each of these areas, there's been a lot of activity in the creation of new businesses to stake out a niche in the legal market and pursue it in a way that you couldn't do just a couple of years ago.
Interesting. Referral fees to non-lawyers in Florida, that we'd call those runners. And
I should say it differently. It's not just referral fees, but it's really the sharing of fees.
Yeah.
You
wow.
share.
It's interesting. Different jurisdictions allow for, referrals, and you got to work the matter or you don't, it kind of runs that interesting 30,000 foot level. Thank you. And then you've already shared a little bit about what your firm's doing. And I'm looking here at the clock because we still got a lot of ground to cover, and I want to make sure we don't run out of time. Carson, 30,000 foot level, what you got going on in Utah?
So Utah's approached it a little bit different than Arizona. We do not have the ability to just share fees across the board. You can apply to the Office of Innovation. It is overseen by the Utah Supreme Court. We have quite a few participants in that, some law firms, but mostly non-attorney owned firms that are getting involved there in technology. Our firm is one of those. We are participating, and we are what would be deemed non-lawyer owned, even though many of our owners are still attorneys. It's been I think getting the dialogue out is really crucial, not just to the public about what our services are, but but to other attorneys about what this can mean. I was in a conversation last week down in Arizona with some, and they brought up, well, this seems really messy. There's all these questions that are unresolved. How will this work? How will that work? And you know what? You're right. It is new. It's innovation, and it is a little bit messy. But our market shares are decreasing. Our access to the public is going down across the board. I found it interesting that many of the people who had concerns about venture capitalists coming in or people just coming in for return investment, they were in areas of the law that were almost entirely dependent on marketing companies generating their lead flow. And so they don't have access without those companies in the first place. I think we should get a lot more involved across the country about what this should look like.
Yeah.
And there are a lot of good questions. There are
I mean, it's really fascinating I just love observing what's going on here. Do you all have this paraprofessional concept in Utah that Whitney describes?
So there is an LPP program that is overseen by the state bar, and their struggle has been a little bit what Whitney just described. There's a fairly high hurdle for it, a fairly narrow definition of what they can do. So they didn't get a lot of, I think we have less than a dozen. Our firm went ahead and in Utah, you can apply to the Supreme Court and ask for different variances and kind of test things out. And that's one of the areas that we asked for and received the go ahead to do. So we're in the process right now of training some of our paraprofessionals to where we get comfortable and can then hold them out in different areas. That's not so much in terms of going into a court scenario, right? Where they can't practice before any court, but as far as being able to meet with the client and kind of triage the client and determine what's needed from there, we think that's going to be extremely beneficial, and we're just getting to that launch right now.
Let me move ahead, and Uri, jump in anytime. And in general, you all have alluded to it. The legal profession itself has been a little slow to jump into this. You know, lawyers risk averse, don't like change. We'll wait and see. Too slow, in your opinions? Legal profession jumping into these models? Whitney?
Nobody wants to just say yes, but I'll say it, yes. Too slow.
And I'm sure, Carson, too slow? Way too slow? And we've talked in the earlier thing, the Utah Supreme Court runs a Center for Legal Innovation website where you can see who's been petitioning. You can see what they petitioned to the Supreme Court. Really something very eye-opening, and we'll send the link to that in our follow-up email, but you can Google it, Utah Supreme Court Center for Legal Innovation. Anything else we want to talk about in terms of kind of the big picture setup, how the profession's responding, who is in fact responding, and jumping in here?
I think the responses are primarily driven by practice areas.
Okay, that was Carson.
Yeah, I was just noting that a lot of the responses that I'm seeing are driven by the practice area and the perception they have from one vantage point. And this is an overarching, much more complex scenario than, okay, we're an end-of-life planning firm, or we're wills and trusts, or we're immigration or family law or personal injury. They're not always the same issues that are being dealt with.
Uri, I mean, again, you got any comment here as to,
well, we have, as we move on, John, to what each of Carson and Whitney have been doing at their firms, one of the questions at registration we got quite a few of, when you registered, we asked you if you have any questions. Pick the next slide, John.
Yep.
At your firms, and I know you'll cover this, but gentlemen, the questions we've been getting is, how did you convince your partners? You know, we've talked about how everyone else has done, but not only, I think, you're not only advisors, but your customers, right? I think both of you at your firms. So how did you convince your partners, and what was the drive at your firm? I think you've both mentioned there's a lot of different advantages. what was most impactful at your firm to make you want to move on?
I can take that. You know, I was prepared to make the case, but I have to say I've had a surprisingly easy time among my partners in terms of pursuing ABS opportunities, in terms of pursuing opportunities made available because of the ability to share fees. I mean, maybe I've been blessed this way. Our firm's been around for almost 50 years, but two of my three founding partners are, you know, still very active in the firm. And one of them was lecturing me just last week about how important AI is and how it's going to be important in the future, and that we need to get on top of it. And I just was chuckling to myself listening to my founding partner talk to me about the importance of AI. So I don't know, maybe I just have an entrepreneurial bunch, but
how about making the non-lawyer a partner?
Yeah, well, so that was a decision that was made entirely based on this individual. We had worked with her before she came to work with the firm. We worked with her at the firm. You know, it was a decision made entirely about her as an individual and her skill set. And I don't think it was a second thought to anyone that she is or is not a licensed member as an attorney of the State Bar of Arizona. To a person, I didn't confront any pushback there.
Wow. How about you, Carson? Why don't you take on Uri's question as well?
We were looking at this for a while before anything was announced. So it took us about a year to get everybody on board. The vast majority were supportive from the beginning, but we did have to work through and talk about some of the concerns that I'm sure most people have. Is a non-lawyer going to come in and tell me what to do? Are they going to get involved in my cases? You know, those types of questions and concerns and structuring. Once we got there, and it did take, you know, a fair amount of discussion and due diligence on our part, then we moved immediately into applying into the regulatory sandbox, and then targeted some great business owners, non-attorneys. I don't like to use that term. I just say successful business owners who we partnered with, and they're complementary pieces to the services we provide. So the clients already have need for those additions. We're now able to bring in good business minds on top of it.
You know, Carson, I don't know how much you want to share about what you're building there in Salt Lake City, but do you mind kind of giving us an overview?
Too, so.
I find, you know, give them data. Here's a great report from Stanford University, Stanford Law School, from late last year, Legal Innovation After Reform, Evidence from Regulatory Change. And it, you know, doesn't find much downside to any of these innovations. So let us move into this notion of any unintended consequences, any downsides we're seeing out there we didn't quite anticipate. Whitney, I'll start with you on that one. Anything going sideways? Anything kind of unintended we didn't see?
I would have liked to have seen more legal paraprofessionals out of the block get licensed. One of the things that we tried to do in Arizona was look carefully at what happened in the state of Washington, because they had a model in place for a number of years. It never got past, I want to say, 40 something licensed folks. And they ended up, I think, closing that program. So I think we need to do better at generating those individuals. As a managing partner, if I can bring in a really qualified LP in Arizona, you can do it in lower level criminal work, divorce work, administrative. There are about half a dozen or so categories. Those individuals, I can train them. I can charge less for them. I can capture market share that I wouldn't otherwise get. So as a manager, I like that as a resource, and I like to have more of it. Probably the biggest unintended consequence, and it's not a negative, is how quickly people who are used to working with capital caught on to our rules. And this has been lawyers like what Carson mentioned, who really rely on marketing to collect their cases, and the money folks that they work with, whose relationships in the past have been, something more of a lender borrower type of situation where lawyers have to take on the risk of borrowing and lenders get stuck with the rates that they negotiate. In Arizona, those groups can now come together. The lawyers can avoid the risk of borrowing because they can have a full money partner who puts their own capital at risk. The money folks can benefit by higher potential margins of return because they're not limited to promissory notes. They can share fees, and so in retrospect, I shouldn't be surprised, but it was people who are used to dealing with capital who really identified Arizona's rules and brought these issues to bear. I think people like me who grew up and practiced in the old system are taking longer to understand all of its potential.
Before we jump over to Carson on this question in Utah, we have a question type in from Tom Grella. Tom used to be the chair of the ABA's Law Practice Division. He's in North Carolina and asks to Arizona, to Whitney, are lawyers permitted to agree to non-competes in your jurisdiction?
No.
No.
No, our rules have never permitted that, and they still don't.
Okay, a specific question. So Carson, anything unintended going on in your jurisdiction?
Now that these are in place. To follow up a little bit on that question that was posed, certainly Utah, the same way as I think just about every state, you cannot put a lawyer with their clients and restrict the client's right to choose, right? The irony is if you are a W-2 employee attorney with one of the tech companies or in a non-law firm, I don't know that they can enforce some of those. And it's not so much stopping the client, but moving out with what they might consider to be trade secrets or other information. I think that's an interesting question that is yet to be answered across the board. If you're not in a law firm, you're not an attorney with your own clientele. But I think there'll always be a lot of unintended consequences as when you move into anything that's new and adventurous, and some are going to be positive and some are going to be things that need to be changed and picked up. One of the things that I believe I know we're learning is it just takes a long time to implement everything. We would have loved to have done everything inside of 12 months, and then we look back and we go, well, we did a lot in 12 months. I just wish we were 5 years down the road. And to really get data and good information to make the business relationships, deploy them, train staff from new. We don't have anybody to copy, right? This isn't something that I can go and look and say, well, this has been done really great in California or in Texas or Nevada. We are very much pioneering that, and that means we're building and training those things from scratch, and it takes longer.
Have any of the big firms, the AmLaw 200, jumped into these alternative business structures in either of your jurisdictions?
I think a lot of people might argue that the big four have been this for a long time globally.
I would argue that for sure. But we're not seeing the big law firms jumping in. The brand names we all know and love.
I'm seeing some of the partners in those firms who I know are active in the area, either representing ABS clients, for example, or otherwise interacting with them. But at a firm-wide level, I'm not hearing very much.
Have you seen, Whitney, any firms set up in Arizona, Phoenix, what have you, to play in the sandbox? They might not otherwise be there, but they want to get into the mix and somehow participate. Are you seeing any of that going on?
Yeah, excuse me. We are seeing that. We are seeing. Like I said, we're up to about 40 now. A good chunk of those are from outside of Arizona, wanting to be the technology firms. The and by the way, that
technology firms for the most part. They're not,
yeah,
not the big.
and that's where you see some of the big dog law firms getting in the mix, working with them. The other thing that you see, and I know that Carson, you had it in Utah as well, is what I mentioned before. You've got firms that are lawyers teaming up with accountants, lawyers teaming up with financial planners, lawyers wanting to interact with their full staffs in equity ways that law firms have traditionally been prevented from doing. And then the other thing in Arizona, we've seen it in a few examples, is the organization of community-focused legal groups, maybe lower income-focused legal providers, forming ABSs as a way to bring resources together and then to broaden their reach across the state. So you let your imagination run wild. I think that there's just been a lot of innovation, and we're just now starting to begin to see the number of these different organizations.
So I'm chatting with more, senior lawyers and such, and you talk about this whole concept of alternative business structures and multidisciplinary practices. They go off on the attorney-client privilege. And where do you draw the line if you're offering tax and consulting and accounting and financial planning and legal services, by the way? How is attorney-client privilege impacted in Arizona, and then Carson in Utah? How is that, maintained?
The short answer is that it's not changed. It's not affected. One of the things that you're required to do in forming an ABS in Arizona is implement procedures that you have convinced the Supreme Court will work to maintain ER 1.8 and all the confidentiality, conflict of interest, maintain confidentiality, including across your non-lawyer owners, and in Arizona, you're required to have a position that we call the compliance lawyer. So ultimately, in each of these organizations, there is an individual who is responsible on pain of losing their license to ensure that the ethics rules are honored. And Carson, I'd like to hear you maybe talk a little bit more how in practice you guys can accomplish that.
Yeah, your model, Carson, how you assuring that?
It's a big challenge, right? And it's very important. I guess I would break that up into two aspects. First of all, the privilege side, which rests with the individual, with the client, the consumer, and their expectation, and our obligation as attorneys to maintain that. And there's a lot of ways that can be breached just in a traditional setting. Mm-hmm. So that doctrine and how it evolves, I think, is really important. As far as actually sharing information, the key there is first and foremost disclosure, right? That you sit and you talk to the client about it, you talk about the pros and cons. This happens all day long in every firm across the country anyway. If you're working on a transaction and you're working with non-attorneys, real estate companies, mortgage companies, title companies, tax practitioners, all sorts of various professionals, you're sharing information, and that potentially opens up the attorney-client privilege. So you need to be very wise on how you're doing that, and most importantly, you've had those conversations with the client. The average client, so if we get down to the access to justice and kind of your bread and butter across America, privilege is less of an issue. In other words, they're kind of expecting to just get the job done and get to work, and they're not prepping or protecting from a major litigation issue or compliance blunder inside their business. So I do think it's something that needs to be addressed and needs more thought on it, though.
I think, Carson, you hit it exactly on the head. When you look at the client, you tell them who's sharing your information. They want to know one question. And it's the same question they ask their financial people. It's the same question they ask their IT people. Is my data safe? Are you going to be treating it confidentially? And you know what? You're going to say yes. So I think you're right, Carson. It's something that we've made up in our head that's this big insurmountable.
I don't know the answer to this. There might be a good lawyer on the call somewhere. with all the IT departments and how they replicate data and put it in backups and spread it all around the cloud and the globe, where are we really at with privilege anyway? I mean, information seems to be replicated everywhere and could be hacked at a moment's notice. And I know that that's a concern for any managing partner, is how to protect their information. And it's being attacked every single day from hackers that have far more resources than we do.
Their Troutman Pepper just got hacked apparently this week, and a big fallout of information causing them lots of problems.
Yeah,
security is important. So as we roll toward the end of our program, we got a few minutes left, and if anybody has any questions, go ahead, type them in. We'll try to get there. But I wanted to close with this one. It seems like overall you all think that this has been a good thing. Good thing for the bar, good thing for the consumers, good thing for the courts. Am I accurate there, Whitney? Has this been a good thing for Arizona, you think? And I'll go to you, Carson.
So far so good, but we're just at the beginning. One thing that the folks attending, also want to be keyed into, and it's one of the reasons why an Arizona ABS, for example, doesn't solve all solutions, and that is because for everyone that's licensed in a state that's not Utah or Arizona, you can share fees perhaps with an Arizona lawyer, but you can't necessarily share fees otherwise in violation of your own state's rules. And if you team up with an Arizona lawyer or an Arizona ABS, it might put you in violation of your rules in other states where you're licensed. And so this was something that I had to learn quickly as I began working with out-of-state lawyers who wanted to take advantage of some of Arizona's rules. And that's just something to tuck away. States, I think, will eventually come to a model similar to what you're seeing in Arizona and in Utah. But the first thing that they might need to do is loosen the rules so that, Texas lawyers and Arizona lawyers can work together under Arizona's rules without jeopardizing somebody's license in Texas. And right now, I think that's still kind of open water.
Carson, why do you think this hasn't more rapidly set up in other jurisdictions? I'm kind of confounded. Uri and I do this big bold predictions webinar every year now, and 2 years ago, oh yeah, this is sweeping the land.
2 years ago, you said that, John. John said that.
I did say that. Coming soon to a jurisdiction near you, and it just hasn't happened. Of course, COVID got thrown into the mix. But do you think more states are going to come around?
I believe so. If you would have told me 25 years ago that 2 states would have moved in this, I wouldn't have believed you, right? So the fact that in the last couple of years we already have 2 states in, we have quite a few states, probably 15 to 20, that are in that exploratory mode. Some of them moving down towards opening up various levels of opportunity and innovation and change. Some waiting for data, and some more concerned about change in general. The discussion's happening though, and people I talk to in almost every jurisdiction, that even those who are very concerned about how this might evolve and what it looks like, they feel it's going in that direction anyway. And I think that's accurate. One of the things we looked at as a partnership when this first came out is this going to go backwards? And we don't believe it is. So while we can't predict exactly what this will look like over the coming years, I do believe it's going to continue to spread and evolve, and we're going to have to be nimble on that front. The second piece is, when you set up a timeline of why this hasn't caught on or not, it takes time. If you're a state that was caught off guard that Arizona and Utah jumped into it, and I would guess most were. The practitioners in Utah certainly were. It kind of came up kind of quick, even though they've been looking at it for a while. It takes time to get your committees together, to have the conversations at the state court level, the Supreme Court level, your bar, your legislators, and to kind of decide what you want to do. it takes a lot of time for the people doing an ABS in Arizona or in the Office of Innovation in Utah to implement their plans. It's great to have it, but it takes a lot of time. And so I actually think it's moving quicker than we perceive. You can't always see all the movement that's taking place until it drops.
Which states do you think might be next in? I mean, is California close? You get Texas, California, New York, Florida moving. You got 50% of the lawyers in the country there, throw in Illinois. Do you think one of those big states is going to jump in anytime soon? Who do you see?
I wouldn't venture a guess on that.
All right. Whitney, you want to take a guess? We tried to get former president of the Florida bar to join our original panel back 2 years ago on this topic, and oh my goodness, no. And
that was right around the time that Florida was giving a hard no.
The big 49 to nothing vote by the Board of Governors. I mean, whoa, slam the door shut on that. But I don't know. I think Florida's revisiting it a little bit.
I think everybody's visiting it and watching.
Mm-hmm.
And
watching. Uri, you're over there, with the New York, New Jersey crowd. Got a lot of close relationships with mid-sized firms in that part of the country. What are they looking at, if anything, in terms of ABSs?
I think firms and partners are getting more comfortable. We haven't talked about succession today, but succession, investments, stretching out the investment on the corporation. There's a lot of interest in that now at firms. So I do see firms interested. Litigation funding. There was a AmLaw story yesterday. Today's journal talked about litigation funders are out there forwarding resources, and they might be getting involved as soon as they can, is what they say. So I think the ground is getting better for that from the inside, from the firm side.
It's going to be interesting to watch over the next several years, and we're going to stay on top of this at Managing Partner, and probably ask Whitney and Cunningham and Carson to come back to us and bring us an update, and perhaps other managing partners from other parts of the country will join that conversation. And we thought it might be fun to, at the outset, we asked what your personal opinion of all this stuff was, and you told us. And we just thought at the close of the conference, we might reset this question just to see if we persuaded any minds to be a little more favorably disposed to this concept. Or, hey, no, this has made me even more nervous and opposed to the concept. And as people are voting, we're still holding most of our participants here. And I don't know, the votes coming in, again, far from scientific, but we may have changed some minds here this afternoon. And certainly going to be interesting to watch. I'll ask each of you, any parting comments to folks on the call, what you think they should tune into, where to go for more information. Carson, we got the Center for Legal Innovation run by the Utah Supreme Court. Any other places, any other guidance you might offer today's listeners?
Just get involved in the conversation. I think, you pointed out the research done with the Stanford professor. Get involved, especially on what's happening outside of the legal industry and how it's affecting your firm. This is very much personal and specific to the firm. The bigger picture is how it's affecting society as a whole, because they will find access to get the services done, and they'll either find them through attorneys or it'll be through a tech company, AI and form-based. And if that scares you, then get proactive on participating in what this should look like going forward.
And Whitney, what guidance?
Our Supreme Court puts out quite a bit of information on its website on both the legal paraprofessional as well as the ABS programs here. But with all things Managing Partner Forum, John, People are always welcome to reach out to me and try to answer questions as best we can on the listserv or otherwise. That's one of your superpowers, is you get us to talk to people.
Well, you know, we want to be there and be that community, and among the resources managing partners come. And both Whitney and Carson are kind enough to agree to anyone who wants to carry forth the conversation. They're the emails, they're their phone numbers. And if you want to talk to Uri and me, we're always happy to chat as well. But, you know, really interesting conversation. We're certainly going to stay tuned. And thank you again, Whitney and Carson. Before we call it a day, Uri, I'll give you the last opportunity to give us a parting shot.
My parting shot is not a happy one. My parting shot is Carson is right. Look where the economics are. Look where the client is. They will find the cheapest, best solution. And our guidelines and our bar rules, be damned, eventually they'll go around us. So the question is, fight them or be part of them. Is that too negative, John?
Wow, that's very inspirational, Uri. Thank you. Hey, everybody, thanks for being with us. We ran a little over, apologize about that, but a special thanks to Whitney and Carson for their insights and their contributions to our conversation. Reach out to us. We'll be sending follow-up early next week. Usually I try to get it out, you know, next day, but early next week, we'll send some follow-up, and, you know, stay tuned. Thank you for being with us, and have a great afternoon, everybody.
Thank you, everyone.
Bye-bye.
Bye, all.